Are you partly to blame for your slip and fall in New York? If you have had a slip and fall in New York and you think you were partly to blame for your accident, you will need to be aware of a few legal rules that could affect your claim. If you were injured on another person's property. If you were injured on another person's property, you will need to prove that the owner of the property was negligent, and their negligence caused your accident, which resulted in your injuries. You will also have to be aware of the Statute of Limitations, and the rules on comparative negligence. Both of these factors can affect your claim and make a real difference as to whether you receive compensation. Let's take a look at these factors now. The Statute of Limitations. The Statute of Limitations puts a deadline on your claim and limits the amount of time you have to file your lawsuit. If you miss the deadline for whatever reason, your claim will be dismissed. In New York, the statute of limitations for a slip and fall is within 3 years. The time begins on the date of your slip and fall. Ideally, you will allow yourself plenty of time between your accident and the statute of limitations. What this means is that if you have a slip and fall in New York, you should not wait until the deadline is almost up. You should give yourself as much time as possible. If you rush things, you may not give yourself enough time to take the case to court should you need to, or discuss your settlement. Make sure you have at least 9 months before the deadline, but give yourself a lot longer if you can. Comparative negligence. Comparative negligence deals with whether the injured person, the plaintiff, was negligent before they slipped and fell. This type of negligence is comparable because the jury needs to compare just how negligent the plaintiff was in comparison to the property owner's negligence. The defendant will need to raise this issue and work to establish how comparatively negligent the plaintiff was. In simpler terms, the defendant needs to prove that the plaintiff did something wrong or did not take reasonable care, and therefore caused their injuries. The plaintiff simply needs to prove that the defendant is negligible. How comparative negligence works. A judge or jury will determine how negligent the plaintiff is after they have decided whether the defendant was also negligent. If it is found that the defendant was not negligent, the case will be over. If it is found that the defendant was negligent, the judge or jury will then try to determine if the plaintiff was negligent too. If the judge or jury finds that the plaintiff was negligent, they have to work out how negligent the plaintiff was in comparison to how negligent the defendant was. For example, the judge or jury may find that the defendant was 75% negligent, and the plaintiff 25% negligent for the plaintiff's injuries. This means that the plaintiff was 25% at fault for their injuries. One of the most important things that needs to be understood in comparative negligence cases is that the plaintiff's negligence will affect the amount of compensation they receive by their percentage of fault. If your case goes to trial, New York's pure comparative negligence rule will apply, and this states that if you were partly to blame for your slip and fall, your settlement will be reduced depending on if you were at fault, and how much you were at fault. You should also be aware that even if your slip and fall case does not make it to court, the property owner may be worried about the case ending up in court. In cases such as these, the settlement offer is likely to reflect how much the property owner thinks you are at fault. This is why it is very important that you make sure you have a strong case and one that proves the owner of the property is liable. If you are unsure as to whether you are partly to blame for your slip and fall in New York, please speak to a lawyer as soon as you can.